Welcome back to the program. It's the Vicki McKenna Show. And standing by is Lucas Vebber from the Wisconsin Institute for Law and Liberty. We talked some months ago about something that's called Act 247 in Wisconsin. And Act 247, which means nothing to anyone, means that the state of Wisconsin legislature, against the prohibitions, the explicit prohibitions in the Wisconsin Constitution, permitted online sports betting via apps, via phone apps. Not only allowed that to take place, but also then gave monopoly control over that process to Wisconsin tribes. Lucas Vebber is standing by. You now have some clients you are suing over this particular law as a violation of the Wisconsin Constitution. Explain what the problem is here.
Yeah, so thank you for having me on the program. The people of Wisconsin in the early 1990s, in response to a rise in tribal gaming in our state, adopted an amendment to our Constitution that explicitly that says the legislature may not authorize gambling in any form. It's Article 4, Section 24 of our Constitution. It's plain as day. What the legislature did here is they passed a bill, Act 247, that you just explained, that amends the definition of a bet to allow certain kinds of bets to be placed in Wisconsin as long as they're connecting to a server on tribal land and meet those requirements. That bill itself, Act 247, violates plainly the terms of Article 4, Section 24, because it's an authorization of a particular form of gambling. It's allowing you to place a bet. It just violates exactly what the Constitution says, and if they want to do that, there's an easy way to do it. They just have to amend the Constitution first. And that's something they didn't do. They're trying to make an end run around our Constitution, and they can't do that.
No. Okay. So this constitutional amendment says there's explicit types of gambling we will permit: the state lottery, bingo, raffles, parimutuel betting. They seem to be trying to take the idea of online sports betting, which isn't even in this at all, which is a form of gambling, and redefine it under the definition of the word bet, because some betting is allowed under this constitutional amendment. And it seems like they're trying to claim it's okay because it's just amending the gaming compact. It's not amending the Constitution illegally. We're just renegotiating a gaming compact using legislation.
Exactly. That seems to be the argument they're making. And, we think that just doesn't fly, that the Constitution is very clear here, and that the legislature, the important thing here is this: the legislature has broad powers under our Constitution. They have the legislative power, right? The people of Wisconsin at statehood gave them all of the powers, the legislative powers that exist. What they did through this amendment in the early 90s was take away power from the legislature. They said, hey, you've got a lot of power, but you don't have this power. And what the legislature did in passing Act 247 is they said, nah, we do have that power. We're just going to do it anyways. And they passed it. And you can't do that. And that's what our lawsuit says. And we're asking a court to declare that the act is unconstitutional for that reason, among others.
So here's a question I have for you. We have exclusive categories of gambling: state lottery, bingo, raffles, and parimutuel betting. So betting on dog races, things like that. How did we get casino games?
Yeah, so it's actually really interesting legal history here. But from statehood, basically, Wisconsin banned all forms of gambling. First 100 years of statehood, 110 years or so. Then there started to be amendments to allow things like charitable bingo, raffles, parimutuel wagering, various constitutional amendments over the past 80 years or so that allowed this. And then in the late 1980s, there were a couple of court cases where tribes wanted to offer casino gaming on their lands. And then there was the Federal Indian Gaming Regulatory Act, which basically said states, if you don't ban gambling, tribes are allowed to do it. So there was a court case in Wisconsin where the question was, does Wisconsin ban gambling? What the court concluded there was that because Wisconsin allows some types of gambling, it doesn't outright ban gambling. So it would be allowed under to have a gaming compact to do this, right? The people of Wisconsin responded to that with this constitutional amendment. The gaming compacts were later expanded, of course, and there was a couple of Wisconsin Supreme Court cases from the early 2000s which basically said that the gaming compacts themselves, because they were entered into prior to this amendment, they could be amended to allow this stuff to happen, to allow some of these expansions to happen. But for something like placing a bet here in Wisconsin, that's outside of tribal lands, that's on state land. So if you're going to decriminalize the placing of a bet here anywhere in the state of Wisconsin on a mobile device, that bill to do that would still violate the state constitution, and the legislature can't do that.
Let's just assume that there was no legal errors in the reasoning that allowed casino gambling in Wisconsin. It was done under the compact, and so it has to be done on tribal land. So this is the compact. It's a contract between the tribes and sovereign land and the state of Wisconsin. Those are what the compacts are. And so in the compact, what is not in the compact? Mobile sports betting off tribal land. So I guess maybe the answer is you could always renegotiate the compact, or you could change the Constitution. But it doesn't seem like saying some guy sitting in the middle of a field, waiting to take a shot at a turkey could bet on a football game on his phone. That doesn't really seem like it falls under tribal gaming compact territory to me.
Exactly. And that's federal law, comes involved here. They will, assuming the governor right now is engaged in these talks to amend the compact to allow this pursuant to the new state law that's ongoing. If they do reach an agreement and try to amend the compact, that amendment itself would be presented to the Trump administration for review. So the Secretary of the Interior would have to approve that gaming compact amendment. So there are a couple other stages of review here, independent of our litigation.
And it seems to me they still couldn't say you can do it anywhere in Wisconsin, because right
Correct,
now
yeah.
you can place a bet online, but you got to be in the parking lot of a gaming facility, of a tribal gaming facility. You have to connect to their servers physically at their facility, and then you can place a bet in the book, right? You can't just say through a compact. It seems to me, at least I can't imagine the Secretary of the Interior would say this. The Bureau of Indian Affairs would agree to this, that anywhere in Wisconsin. Now, maybe Francesca Hong, who thinks the entire state is stolen land, maybe she thinks differently, right? But we don't. We have treaties in place that say it's not stolen land. So even if the compact gets renegotiated and the app-based gambling is expanded, it still doesn't seem to me like you can do it anywhere in Wisconsin. Like you can't be sitting in the Walmart parking lot placing a bet.
Exactly. Well, that's why, and their argument has been that they needed to amend state law through Act 247 to make that legal. And our argument in this lawsuit is, regardless of whether, essentially the compact would allow that or not, you can't pass that law to make it legal, because
right.
When something was previously prohibited by law and now it's allowed, you've therefore authorized it, and it violates the Constitution. So
if it stands, then other constitutional provisions and principles can be overridden by legislation as long as enough people and enough lobbyists support it. And that's not how it works. We put things in the Constitution because there's a sense of permanence to them, because they can't be easily overturned. You want to overturn it, 2 successive sessions of the legislature, put the question to the voters, ask the voters if they'd either like to overturn this amendment or expand it to include mobile gaming. There's another problem with mobile gaming, Lucas, and that is it's devastating. It isn't the same as the effort it takes to drive to the casino. That takes effort. It isn't the same as, wasting $25 on lottery tickets. This has wrecked particularly young people, particularly young men, but it has wrecked their financial conditions. The organizations, the companies we're talking about here induce additional bets in ways that are what one could say would violate the principles of how you treat an addict. And that's not a small thing.
No, and that's, part of the reason why I'm sure the people of Wisconsin, 30 years ago decided to put this in the Constitution. The legislature couldn't authorize this. So, there are real public policy issues here that need to be addressed, and simply, ignoring the Constitution to pass a bill to give a monopoly to one specific group of people is not allowed under our Constitution, and
Right.
That's why we filed the lawsuit.
So there's another thing. It's only the tribe. So FanDuel couldn't come in and DraftKings couldn't come in. No, the 100% of the manipulation of people, who are hooked on online betting, which, by the way, introduces people who would never gamble. They would never drive to a casino. but yet there it is on their phone. That would be controlled by one entity. So there wouldn't even be competition. But here's the thing. If you, maybe Wisconsin wants it. I don't know. I don't. All right. I think it's terrible, but maybe people in Wisconsin want it. Then have the legislature show all of the emails coming from regular people saying, it'd be nice is if I could place a bet on DraftKings or I could place a bet on my phone. That would be nice. And then they could actually craft legislation that could say things like, once somebody is tapped out, you cannot induce them to take out loans on their credit cards. You cannot induce them to take out second mortgages. You could put protections into place if you were careful about this, but they're not being careful and they're being unconstitutional.
Exactly. And there was a question in the market law poll on this, and I think 64% of Wisconsinites opposed online sports betting. And it was a bipartisan cross section. Both parties opposed it. So an interesting public policy issue. And I, as you noted, this does only benefit one particular group of people. That is a separate claim, an equal protection claim that we are raising in our complaint. The bill creates an unconstitutional racial classification, conferring a benefit upon Indian tribes and their members alone to run these. And state governments, like the state of Wisconsin, doesn't have the constitutional authority to do that. And so we think it violates equal protection as well, independently of the ban on gambling. So those claims will be brought before a court, and we hope to get relief as soon as we can.
So are we bringing this into federal court, or is this going into state court?
This is in state court. Yeah, these are state constitutional claims. So.
Okay, so the equal protection claim is going to be a state constitutional claim. The anti-constitutional nature of the legislation is a state constitutional claim. I think the equal protection claim is interesting. It would seem to me if you are going to do this, you should allow other companies to come in and participate as well, which, by the way, the other companies said the same thing when they registered against this legislation. But let's ask us for a change and don't just, get your palms greased by a lobbyist, which is what happened here. I think this was a voice vote, too. I don't even think they had a roll call vote, did they?
I don't recall, actually.
I don't think it was a roll call vote because nobody wanted to take claim of this particular piece of legislation. All right, so we're off to the races on this one. Of course, Wisconsin Institute for Law and Liberty. Lucas Vebber, thanks so much.
Thanks for having me, Vicki.